The certified letter arrived on a Tuesday morning, delivered to Sarah Chun's century-old farmhouse just as she was heading out to feed her horses. Inside the expensive cream envelope, HOA President Melissa Bradford informed Sarah that the private gravel access road crossing her property was actually community property, and Sarah needed to stop using it for her agricultural vehicles within 30 days or face legal action. Sarah, a 47-year-old equine veterinarian who'd inherited this 200-acre horse farm from her grandmother, read the letter 3 times while standing in her kitchen, mud still on her boots from morning chores. The road Melissa was claiming, the same road Sarah's family had built in 1924 to access their back pastures, apparently now belonged to Meadowbrook Commons. HOA because it provided essential access to their development. Never mind that Sarah's family had owned this land for 98 years. Never mind that the HOA development had been built just 5 years ago on former farmland her grandmother had sold. Melissa Bradford had decided the road was hers, and she'd enlisted expensive lawyers to make it official. What Melissa didn't know was that Sarah had recently discovered something interesting while researching her property's history for a historical registry application. That private gravel road Melissa wanted so badly, it wasn't just an access road. And the legal battle Melissa was about to start would end with her losing something far more valuable than she'd ever gain. Where are you from? Tell us in the comments below. And if you're enjoying this story of property rights justice, hit that like button and subscribe for more incredible tales. Now, let's see exactly how this unfolded. This is a story in 3 acts. The land grab that pushed a patient woman past her breaking point. The legal battle where property deeds spoke louder than HOA demands. And the court decision that turned one woman's greed into a lesson about respecting boundaries. The first part reveals how a peaceful horse farm became the target of HOA expansion. You'll experience Sarah's growing frustration as Melissa Bradford, president of the neighboring development's HOA, systematically tried to claim portions of Sarah's family land through increasingly aggressive tactics. What started with requests to share the access road escalated into outright ownership, claims backed by lawyers who clearly hadn't done their homework. Every conversation ignored Sarah's property rights. Every legal letter assumed the farm was somehow subordinate to the 5-year-old HOA, until the day Melissa made a claim so outrageous that Sarah realized she wasn't dealing with someone who could be reasoned with. She was dealing with someone who needed to be stopped in court. Second part takes you inside the legal discovery that changed everything. Sarah's research into her family's property history, originally intended for a historical preservation application, revealed documentation that Melissa's lawyers had completely missed. Deeds, surveys, and county records that told a very different story about who owned what. You'll watch as Sarah's attorney uncovered not just proof of Sarah's ownership, but evidence that Meadowbrook Commons HOA had been illegally using Sarah's property in ways that went far beyond the disputed access road. The moment Sarah realized she didn't just have a defense, she had grounds for a countersuit that would make Melissa wish she'd never sent that. First letter. The third part delivers the courtroom. Justice and unexpected consequences. How a routine property dispute hearing became a masterclass in the importance of proper title research. The judge's reaction when Sarah's evidence was presented. Melissa's face when she realized her land grab had backfired catastrophically. And the final court order that didn't just protect Sarah's property rights. It stripped the HOA of access they'd been illegally using for years, forcing them into an expensive solution that affected every homeowner in Meadowbrook Commons. Here's exactly what happened when one entitled HOA president learned that old farms have better lawyers than new developments. Sarah Cheen had never wanted to be a farmer, but life has a way of changing plans. The 47-year-old equine veterinarian had built a successful mobile practice treating horses across 3 counties, spending her days in barns and arenas rather than at a desk. When her grandmother Eleanor passed away 3 years ago, Sarah inherited Willow Creek Farm, 200 acres of rolling pasture, woodland, and memories in rural Whitfield County. Her grandmother had operated it as a modest horse boarding facility, keeping 12 to 15 horses for local owners who needed quality care. Sarah had grown up riding these trails, mucking these stalls, learning veterinary medicine by watching her grandmother treat everything from colic to complicated foaling. Keeping the farm meant restructuring her practice, hiring an associate vet, and learning the business side of property management. But standing in the same barn where 4 generations of Chun women had worked with horses, Sarah couldn't imagine letting it go. The property had been in her family since 1924, when her great-great-grandfather purchased the land and built the original farmhouse. The gravel access road winding from the county road back to the pastures and barn had been constructed that same year, hand-laid by her great-great-grandfather and local workers, creating a vital artery for moving equipment, livestock, and supplies across the property's varied terrain. Meadowbrook Commons hadn't existed when Sarah's grandmother was alive. The development appeared 5 years ago on 40 acres of former farmland that Eleanor had sold to a developer in 2018, needing cash for medical expenses during her final years. The sale had broken Eleanor's heart, but 75 acres of good pasture brought enough money to ensure she could afford quality care without burdening Sarah. The developer, Whitfield Residential Group, had built 85 townhomes in a planned community complete with a pool, playground, and strict HOA covenant promising resort-style living in a pastoral setting. The development's main entrance opened onto County Road 47, the same road that provided access to Sarah's farm. The 2 properties shared about 600 feet of road frontage, though Sarah's farm entrance sat a quarter-mile north of the development's gates. For the first 3 years, the relationship between farm and development was peaceful if distant. Sarah waved at joggers from the development who occasionally ran past her property. Some Meadowbrook residents even boarded their horses at Willow Creek, appreciating the proximity. Then Melissa Bradford bought the largest model in Phase 3, moved in with her investment banker husband and teenage twins, and immediately ran for HOA president on a platform of maximizing property values through community enhancement. Melissa's first contact with Sarah came 4 months after her election. A sunny Saturday morning in April when she appeared unannounced at the farm's entrance. Sarah was repairing fence posts, work gloves muddy, when a silver Mercedes SUV pulled up and a blonde woman in pristine white capris and designer sunglasses stepped out, looking distinctly uncomfortable with the rural surroundings. "You must be Sarah Chun," Melissa said, extending a hand that retracted slightly when she saw Sarah's muddy gloves. "I'm Melissa Bradford, president of Meadowbrook Commons HOA. I wanted to introduce myself and discuss a community opportunity." Sarah invited her to sit on the porch, offered iced tea, and listened as Melissa explained her vision. The HOA wanted to create a community nature trail that would wind through the woods behind the development, offering residents a premium amenity that would significantly enhance property values. The trail would need to cross about 2 acres of Sarah's wooded property to connect properly. "Of course, we'd be willing to offer you honorary HOA membership," Melissa said with a smile Sarah immediately recognized as predatory. "Access to our pool and clubhouse. It's quite exclusive." Sarah had politely declined, explaining she had liability concerns about trails on working farm property with horses and equipment. Melissa's smile had frozen, but she left cordially enough. The second contact came 6 weeks later. This time a formal letter from the HOA's attorney requesting an easement across Sarah's property for the nature trail. The letter explained that such easements were standard practice in community development and that Sarah's cooperation would be neighborly and mutually beneficial. Sarah's own attorney, Tom Morrison, a gruff property lawyer who represented her grandmother for 30 years, had written a polite refusal citing liability and farm operations. 3 weeks after that, Melissa appeared again, this time with 2 HOA board members and a new proposal. They wanted to purchase a 5-acre strip of Sarah's woodland for trail development. Their offer was roughly 40% of market value. When Sarah declined, Melissa's demeanor shifted from friendly to cold. "You're being extremely short-sighted," she'd said. We're trying to be good neighbors, but there are other ways to resolve property access issues. Sarah had asked what that meant. Melissa had simply smiled and left. That's when the real trouble started. In August, Sarah noticed Meadowbrook residents using her access road. Not just walking past the entrance, but actually driving onto her private gravel road, parking near the woods, and hiking onto her property. She put up no trespassing and private property signs. They were ignored. She installed a chain across the road entrance with clear signage. Someone cut it the first night. When Sarah called Melissa to complain, the HOA president had been dismissively sweet. "Oh, Sarah, people just love walking in nature. Surely you can share a little access? It's not like you own the road." Sarah had replied that she absolutely did own the road. It was built by her great-great-grandfather, and she wanted the trespassing stopped immediately. Melissa had laughed. "Actually, Sarah, you might want to check your property records. That road provides essential access to multiple parcels, which creates implied easement rights. But I'm sure your attorney can explain it to you." The call ended with Melissa suggesting Sarah reconsider cooperation before things get complicated. September brought the certified letter that changed everything. Sarah stood in her kitchen reading legal language that made her blood pressure spike with every paragraph. Meadowbrook Commons, HOA, was formally claiming that the gravel access road crossing Sarah's property was not, in fact, her private road, but rather a community access road predating current property divisions. The letter cited something called prescriptive easement by historic use and claimed that because the road had been used by multiple parties over decades, Sarah's family had lost exclusive ownership rights. More incredibly, the letter demanded Sarah stop using the road for commercial agricultural vehicles, including her vet truck, farm tractor, and horse trailer, as these vehicles were damaging community infrastructure and creating safety hazards for recreational users. Sarah was given 30 days to acknowledge HOA ownership of the road or face legal action to establish easement rights. Attached was a proposed settlement where Sarah could continue using the road if she paid the HOA a monthly access fee of $300 and agreed to restrict her agricultural vehicle use to specific hours. Sarah read the letter 3 times, fury building with each pass. They were claiming her road, the road her great-great-grandfather built with his own hands, the road that had served her family's farm for 98 years. And they wanted to charge her for using it while simultaneously banning her farm equipment. She immediately called Tom Morrison, who listened to the letter's contents with increasing disbelief. "This is the most aggressive land grab I've seen in 40 years of practice," Tom said. "They're banking on you not having clear documentation or being too expensive to fight them." He paused. "Sarah, I need to ask, do you have clear chain of title documentation for that road? Original construction records? Historical surveys?" Sarah thought about the boxes in her attic, decades of farm records her grandmother had carefully preserved. "I think so," she said. Grandmother was meticulous about documentation. She said knowing your land's history was knowing your rights. Tom's voice brightened. "Then I suggest you start looking. Because if we can prove uninterrupted family ownership and construction, Melissa Bradford just made $1 million mistake. And Sarah, while you're researching, look into exactly where Meadowbrook Commons' property lines actually are. I have a feeling their attorneys didn't do proper title research. And if they're using any of your land without permission, we might have grounds for a countersuit that'll make them regret ever hearing the name Willow Creek Farm." Sarah spent the next 2 weeks in her attic, barn office, and county records building. What she found was better than she'd imagined. Her great-great-grandfather hadn't just built the access road, he'd filed detailed surveyor maps with the county in 1925, clearly marking it as private farm infrastructure serving his agricultural operations. Her great-grandfather had maintained those records, updating them in 1954 when he expanded the road to accommodate larger equipment. Her grandmother had commissioned a complete survey in 1989, showing the road entirely within Willow Creek Farm's boundaries, never crossing into or serving any adjacent properties. But the real discovery came when Sarah requested historical aerial photos from the county planning office. The photos from 2018, taken before Meadowbrook Commons was built, showed something interesting: the development's rear parking lot, built to serve the community pool and clubhouse, extended approximately 40 feet onto what had been part of the farmland Eleanor sold. But according to the deeds Sarah found, Eleanor had only sold 75 acres, specifically excluding a 5-acre parcel that included a spring-fed pond and surrounding buffer zone. Sarah pulled out the current county tax maps and overlaid them with the 2018 aerials. The parking lot, the one serving Meadowbrook Commons' premium amenities, the one residents paid HOA fees to access, was built partially on land that had never been included in the sale. Land that, according to every document Sarah could find, still belonged to Willow Creek Farm. Melissa Bradford wasn't just claiming Sarah's road. She built her HOA's parking lot on Sarah's land without permission, without easement, without any legal right whatsoever. Sarah sat in her grandmother's office, surrounded by a century of carefully preserved records, and smiled with cold satisfaction. Melissa wanted a legal battle. She was about to get one that would cost her far more than some gravel road access. Tom Morrison reviewed Sarah's documentation with the focused intensity of a lawyer who'd just been handed an airtight case and a legitimate grievance. Spread across his conference table were survey maps from 1925, aerial photographs from 5 decades, county records showing uninterrupted Chen family ownership, and the devastating overlay proving Meadowbrook Commons had built 40 feet of parking lot on Willow Creek Farm property. "This is extraordinary documentation," Tom said, looking at Sarah with something approaching awe. "Your grandmother preserved everything. Most farms this old have gaps in their records, disputed boundaries, unclear ownership chains. You have 98 years of continuous documented proof." He tapped the aerial overlay. "And this parking lot situation? Sarah, this isn't just trespassing. This is structural encroachment on your property. They paved over your land, installed lighting, painted parking spaces. That's not something easily corrected." Sarah leaned forward. "What are our options?" Tom smiled grimly. "We respond to their demand letter with our own. We prove your ownership of the access road so thoroughly they'll look foolish for ever questioning it. And then we politely inform them that their parking lot is partially built on your property without permission. And we'd like to discuss compensation for 5 years of unpaid use." The response letter went out on October 15th, delivered by certified mail to both Melissa Bradford and the HOA's attorney, a firm called Whitfield & Associates that specialized in real estate development. Tom's letter was a masterpiece of legal precision wrapped in courteous language. It opened by thanking the HOA for bringing the property boundary matter to everyone's attention, then systematically dismantled every claim in their original demand. The access road was documented as private farm infrastructure built in 1924 by Sarah's great-great-grandfather, with county-filed surveys from 1925, 1954, and 1989 all confirming it as exclusively serving Willow Creek Farm operations. No evidence existed of historic public use, community access, or any easement rights. The road had never served adjacent properties because no adjacent properties existed until 2019. The letter then pivoted to what Tom called the unfortunate discovery made during Sarah's title research. Attached were aerial photographs, survey overlays, and county records proving that approximately 2,400 square feet of Meadowbrook Commons' rear parking lot had been constructed on property that remained under Willow Creek Farm ownership. The letter noted this encroachment appeared unintentional, likely resulting from inadequate survey work during development, but nevertheless represented 5 years of unpaid land use. The letter concluded with 2 options. The parties could resolve this matter amicably through negotiated settlement, or Sarah would file suit for both declaratory judgment on the road ownership and compensation for the parking lot encroachment. Tom suggested they respond within 14 days. The response came in 11 days, but not from Whitfield and Associates. A new law firm, Henderson & Co. from the state capitol, sent a tersely worded letter claiming Tom's allegations were speculative and based on outdated survey data, and demanding Sarah cease her harassment of the HOA. The letter dismissed the parking lot issue as unsubstantiated and insisted the access road matter would be resolved through appropriate legal channels if Miss Chin continues refusing reasonable community access. Tom read the letter twice, then looked at Sarah. They've lawyered up with a bigger firm, which means they're taking this seriously. But here's what's interesting. They didn't actually refute your evidence. They just called it outdated without providing their own surveys or documentation. He leaned back in his chair. Henderson & Co. is expensive. Really expensive. Which means Melissa Bradford has convinced her HOA board to spend significant money fighting this rather than admitting they made a mistake. That's good for us, actually. The deeper they dig in, the worse it looks when we prove them wrong. Sarah frowned. How much is this going to cost me? Tom waved dismissively. Your documentation is so solid, we can probably get attorney fees when we win. But Sarah, I want to be clear if we file suit. This becomes public. Your neighbors will know, the local paper might cover it, and Melissa Bradford will make your life difficult however she can. Are you prepared for that? Sarah thought about her grandmother, who maintained this farm through the Depression, World War II, 3 recessions, and the steady encroachment of development. Eleanor Chun had been 5 feet tall and soft-spoken, but she'd fought off developers, defended property rights, and never backed down from someone trying to take what wasn't theirs. File the suit, Sarah said. My grandmother didn't preserve 98 years of records, so I could hand over family land to an HOA president with an entitlement complex. Tom grinned. That's what I was hoping you'd say. Let's make this educational. The lawsuit Sarah Chen v. Meadowbrook Commons. Homeowners Association was filed in Whitfield County Superior Court on November 3rd. The complaint requested declaratory judgment confirming Sarah's exclusive ownership of the access road, an injunction preventing HOA interference with her use of said road, and damages for 5 years of unpaid land use plus the cost of removing the parking lot encroachment from her property. The filing made local news not because property disputes were unusual, but because the story of an HOA trying to claim a century-old farm road while simultaneously building on farm property without permission was too good for reporters to ignore. The Whitfield Gazette ran a front-page story with the headline, HOA Land Grab Backfires, Farm Seeks Removal of Development Parking Lot. The article included a photo of Sarah standing by her access road gate, alongside historical photos of the road from 1925 and aerial images showing the parking lot encroachment. Community reaction was swift and divided. Longtime county residents who remember Eleanor Chun's farm expressed outrage at the HOA's audacity. Meadowbrook Commons residents, suddenly learning their parking lot might be illegal, were furious at Melissa. The HOA's November board meeting, normally attended by maybe 15 residents, drew over 200 angry homeowners demanding answers. Sarah heard about it from Julie Martinelli, one of her horse boarders who lived in Meadowbrook. It was a massacre, Julie reported, standing in Sarah's barn while her Maury ate hay. People were screaming at Melissa. Someone had printed out the Gazette article and was reading sections out loud. Melissa kept insisting you were exaggerating, that their attorneys said the parking lot issue was easily defensible, but nobody believed her. Do you know how much we pay in HOA fees? $600 a month. And now people are learning that money is going to fight a lawsuit Melissa started by trying to steal your road. Julie shook her head. She tried to adjourn the meeting early, but the board voted to continue without her. They're calling an emergency election to recall her as president. It's chaos. Sarah felt a stab of sympathy for the ordinary Meadowbrook residents caught in Melissa's scheme. "I don't want to hurt your neighbors," she told Julie. "But I can't let someone claim my family's property just because it's convenient for them." Julie nodded emphatically. "Everyone understands that." "Well, everyone except Melissa and her core supporters." "But Sarah, you should know she's telling people you're trying to destroy property values out of spite, that you could easily share the road, but refuse because you hate the development. She's making this personal." Sarah sighed. It was already personal. Melissa had made it personal the moment she claimed ownership of something she had no right to. Discovery in the lawsuit revealed just how badly Melissa's attorneys had failed in their due diligence. Henderson and Co. had apparently relied on a title search that missed the 5-acre parcel Eleanor had retained when selling to the developer. They'd assumed the entire area adjacent to Meadowbrook Commons had been included in the 2818 sale without actually verifying boundaries. When Tom Morrison submitted Sarah's surveyor reports, aerial photograph, and county records, Henderson and Co. went silent for 2 weeks. Their next communication was a settlement offer. The HOA would drop all claims to the access road if Sarah would grant them a permanent easement for the parking lot encroachment and waive any damages. Tom laughed out loud reading it. "They want you to give up 2,400 square feet of your property for free and pretend the last 5 years of unpaid use never happened. I've seen desperate settlement offers before, but this is remarkable." He looked at Sarah. "What do you want to do?" Sarah didn't hesitate. "Counteroffer. They pay me fair market value for the encroached property, not just moving forward, but retroactive compensation for 5 years of use. They drop all road claims and sign a document acknowledging my exclusive ownership. They pay my attorney fees. And Melissa Bradford issues a written apology to me and to her community for starting this mess." Tom raised his eyebrows. "That's aggressive. The apology especially, you can't usually force that." Sarah smiled. "Then we go to court and let a judge decide. But I want them to know what reasonable settlement looks like before we make this really expensive for everyone." The counteroffer was rejected within 48 hours, with Henderson and Co. insisting they'd vigorously defend against baseless claims at trial. Tom filed a motion for summary judgment on the road ownership, arguing that Sarah's documentation was so conclusive no trial was needed on that issue. The hearing was set for January 12th, giving both sides 2 months to prepare. During that time, Meadowbrook Commons descended into civil war. The recall election removed Melissa as president, replacing her with David Kowalski, a retired engineer who'd moved to Meadowbrook for its quiet amenities, not constant legal drama. David called Sarah directly, apologizing for the situation and asking if they could resolve it reasonably. "I've reviewed all the documents," he told her. "You're clearly right about the road, and I honestly have no idea how our previous board missed the parking lot issue. But Sarah, removing that parking lot would cost our community over $400,000. Tearing up pavement, regrading, rebuilding elsewhere. We have reserves, but that would wipe them out and require a special assessment on every homeowner." Sarah felt sympathy for David's position, but she also felt the weight of her grandmother's expectations. "David, I appreciate your honesty. But Melissa didn't just make a mistake. She tried to steal my property and charge me for using my own road. Actions have consequences." David sighed. "I understand. Can we at least discuss fair compensation? Because I'm trying to find a solution that doesn't bankrupt 200 families who had nothing to do with Melissa's schemes." The summary judgment hearing on January 12th lasted less than an hour. Judge Patricia Womack, a no-nonsense jurist with 30 years on the bench, reviewed Sarah's documentation with increasing impatience at Henderson and Cole's weak arguments. When the HOA's attorney tried to argue that community need created implied easement rights to the access road, Judge Womack cut him off. "Counsel, I've reviewed Ms. Cheen's exhibits. She has 98 years of continuous documented ownership, construction records, 3 separate surveys, and absolutely no evidence of public use prior to your client's unilateral decision to trespass. On what legal theory are you basing this claim? The attorney stumbled through an answer about historical access patterns. Judge Womack wasn't impressed. The road was built in 1924 to serve farm operations. It has served farm operations exclusively since then. Your client's development was built in 2019. I'm struggling to see how 5 years of illegal trespassing creates any rights whatsoever. She granted summary judgment to Sarah, declaring the access road her exclusive private property and enjoining the HOA from any use or claim to it. Then she turned to the parking lot issue. This matter will require trial to determine appropriate damages and remedies. But I'm deeply troubled by what I've seen in the record. Mr. Henderson, did your client perform any survey work before claiming Miss Chun's property? Henderson admitted they relied on the developer's original survey from 2018. Judge Womack's expression darkened. The developer's survey of the property the developer was selling, not an independent verification of boundaries before claiming someone else's land was yours. This is precisely why attorneys conduct proper due diligence. She set a trial date for March, but strongly suggested the parties settle. Miss Chun has been extraordinarily patient, given that your client built on her land without permission and then tried to claim more of her property. I suggest you find a reasonable resolution before I'm forced to issue remedies from the bench. The settlement came 2 weeks later, negotiated directly between Tom Morrison and David Kowalski, while Henderson and Cole billed for thousands in attorney hours to save face. Meadowbrook Commons would pay Sarah $125,000 for permanent easement rights to the parking lot encroachment, approximately $50,000 per acre, reflecting fair market value plus retroactive use compensation. The HOA would pay Sarah's attorney fees totaling $18,000. They would record a permanent document with the county acknowledging Sarah's exclusive ownership of the access road and renouncing any claims forever. And in a clause David insisted on despite Henderson and Cole's objections, Melissa Bradford would write a public letter to the Meadowbrook Commons community and to Sarah explaining how her actions as president had led to this expensive settlement, apologizing for the costs imposed on her neighbors, and acknowledging she'd been wrong about the property rights. David explained his reasoning to Sarah during their final settlement meeting. Melissa destroyed community trust and cost us a huge amount of money because she refused to do basic research before making aggressive legal claims. The community deserves to hear her admit it. Otherwise, she'll spend the next 5 years telling everyone this was someone else's fault. Sarah agreed, though she took no pleasure in Melissa's forced humiliation. She'd simply wanted to protect her family's legacy. That Melissa had made it a battle was Melissa's choice. The settlement was finalized on February 8th, signed in Tom Morrison's conference room with Sarah on one side of the table and David Kowalski representing Meadowbrook Commons on the other. Henderson and Cole's attorney attended remotely via video, clearly relieved to escape the expensive trial his client's due diligence failures had made inevitable. Sarah signed her name to the easement agreement, accepting $125,000 for permanent rights to 2,400 square feet of land that would remain hers by deed but could be used by the HOA as parking. David signed the HOA's acknowledgement of Sarah's road ownership, a document that would be recorded with the county to prevent any future board from revisiting Melissa's failed land grab. When the last signatures were dry, David extended his hand across the table. "I'm sorry for everything our previous president put you through," he said. "This should never have happened." Sarah shook his hand, seeing genuine remorse in his eyes. "Your community isn't responsible for one person's mistakes," she told him. "I'm glad we could resolve this reasonably." David smiled tiredly. "Reasonably, but not cheaply. That special assessment letter goes out next week. Every household will pay an extra $800 to cover the settlement and legal fees. I expect my phone will be ringing off the hook." Melissa Bradford's required apology letter was published in the Whitfield Gazette and sent to every Meadowbrook Commons household on February 15th. The letter, clearly written under attorney supervision, was brief and formal. Melissa acknowledged that as HOA president, she had proceeded with legal action regarding property boundaries without conducting adequate due diligence. She admitted the access road belonged exclusively to Willow Creek Farm and always had. She acknowledged the parking lot had been built partially on farm property without proper verification of boundaries. She apologized to Sarah Chun for the stress and expense caused by her actions, and to Meadowbrook Commons residents for the settlement costs they now bore. The letter concluded with her resignation from the HOA board effective immediately. There was no admission of underlying intent, no acknowledgement of the aggressive tactics she'd employed, no real contrition. But Sarah hadn't expected genuine apology from someone like Melissa. The public accountability was what mattered. Melissa had started this fight to expand her little kingdom, and instead she'd lost credibility, her board position, and had forced her neighbors to pay $143,000 to clean up her mess. The special assessment hit Meadowbrook Commons homeowners hard. Julie Martinelli, still boarding her horse at Willow Creek, reported that the March HOA meeting had drawn angry residents demanding to know how this had happened. David Kowalski had methodically walked through the timeline, showing how Melissa had claimed the access road without legal basis, discovered the parking lot issue during Sarah's research, then insisted on fighting rather than settling early when damages would have been minimal. She had 3 opportunities to back down, David explained to the packed clubhouse. When Ms. Chun first refused the trail easement, when her attorney sent the response letter, and when Judge Womack suggested settlement at the hearing. Each time Melissa insisted we'd win, that Ms. Chin was bluffing, that our attorneys said the case was solid. She was wrong on every count. Several residents called for legal action against Melissa personally, arguing she should bear the costs. David had to explain that board members generally have immunity for decisions made in good faith, and proving Melissa acted in bad faith would require another expensive lawsuit. The best we can do, he said, is learn from this and ensure future boards conduct proper research before making legal claims. 3 months after the settlement, Sarah received an unexpected visitor. A woman in her 60s, dressed in practical jeans and a fleece jacket, knocked on the farmhouse door, introducing herself as Catherine Bradford, Melissa's mother-in-law. "I want to apologize for my daughter-in-law's behavior," Catherine said when Sarah invited her inside. "I've known about this property for years. My late husband used to buy hay from your grandmother. Eleanor was a wonderful woman, and she'd be proud of how you defended her legacy." Catherine explained that Melissa's aggression stemmed from insecurity and a desperate need to control her environment. "She grew up without much, married my son who provides a comfortable life, and now she treats every situation like she has to prove she belongs by dominating it. The HOA presidency gave her power, and she wielded it like a weapon." Catherine paused, hands wrapped around the tea Sarah had offered. "My son is divorcing her. Not because of this lawsuit specifically, but this was the final example of a pattern he couldn't ignore anymore. Melissa makes enemies out of everyone who doesn't defer to her, and he's exhausted from cleaning up her disasters." Sarah felt unexpected sympathy. "I didn't want to hurt your family," she said. "I just wanted to protect my land." Catherine nodded. "You did nothing wrong. Melissa brought this entirely on herself. I just wanted you to know that not everyone in that family supported her actions." By summer, life at Willow Creek Farm had returned to peaceful routine. Sarah's access road remained gated and private, with clear signage and a lock that kept out trespassers. The settlement money had funded long-needed barn repairs and new fencing for the back pastures. Sarah even used part of it to commission a historical marker for the property, recognizing its century of operation by the Chun family. The marker stood by the road entrance, visible to anyone driving past, a permanent reminder that some places have histories deeper than any HOA covenant. Meadowbrook Commons had stabilized under David Kowalski's pragmatic leadership. with new bylaws requiring board consultation with attorneys before any legal action and mandatory title research before claiming any property rights. Melissa Bradford had moved out of the development in May, selling her house at a modest loss. Rumors said she'd moved to Arizona, far from the community that now associated her name with expensive mistakes. On a warm August evening, Sarah stood at her back pasture fence watching horses graze in the golden hour light. The access road wound through the property behind her, the same path her great-great-grandfather had carved nearly a century ago to serve his farm. 4 generations of Chen women had walked this land, defended these boundaries, and maintained these traditions. Sarah had worried that fighting a lawsuit meant she was clinging to the past. But standing there watching the sun paint her grandmother's barn in copper light, she understood differently. She wasn't fighting to live in the past. She was fighting to ensure the future had room for places with history, for family legacy, for land that meant more than just development potential. Melissa had seen Willow Creek Farm as an obstacle to her vision of controlled community perfection. Sarah saw it as proof that some things endure despite pressure to conform, to modernize, to surrender identity for someone else's convenience. Her phone buzzed with a text from Tom Morrison. Saw the historical marker driving past. Your grandmother would be proud. Hope you're enjoying that barn repair the HOA funded. Sarah smiled, typing back, best investment Melissa ever made. Even if she didn't mean to. She pocketed her phone and walked down to the barn. Boots crunching on the same gravel her great-great-grandfather had laid stone by stone. Inside, horses nickered softly in their stalls, the evening feeding routine beginning its familiar rhythm. This was her life now, the farm she'd inherited and chosen to keep, defended and preserved for whatever came next. Maybe someday she'd pass it to a niece, or a cousin's child, or someone else who'd appreciate its history enough to fight for it when necessary. That was the thing about legacy. It didn't demand perfection, just stubbornness. The willingness to say no when someone with temporary authority claimed ownership of something that had never been theirs. The courage to stand alone against popular opinion when you knew you were right. The patience to let bullies defeat themselves through their own overreach. Sarah finished evening feeding and walked back to the farmhouse as twilight settled over the property. Inside, she hung her work jacket on the same hook her grandmother had used, washed her hands in the same deep sink, and made tea in the same kitchen where 4 generations of Chen women had planned their days and defended their land. On the wall hung a framed photo of her great-great-grandfather standing beside his newly built access road in 1924, pride evident in his weathered face. Next to it was the deed he'd filed that year, preserved by her grandmother, and ultimately used to defeat someone who thought 98 years of family history could be erased by 5 years of aggressive HOA tactics. Sarah raised her tea mug in silent toast to the photo. "We kept it, grandfather," she said softly. "Every inch." Outside, the historical marker gleamed in the dusk, and down the road, Meadowbrook Commons residents parked in a lot they now knew they were lucky to use. Justice, Sarah had learned, didn't always require destroying your opponent. Sometimes it just required knowing your ground, preserving your history, and refusing to surrender what was rightfully yours to someone whose authority extended exactly as far as their property line and not 1 inch further. 1,500 miles north in rural Montana, retired Army Colonel James Whitmore received a cease and desist letter from his HOA president, Nicole Chin, demanding he remove the unsightly agricultural equipment from his 10-acre property, equipment that included a 1952 John Deere tractor his grandfather had restored, now deemed junk vehicles under new community standards. James read the letter twice, noting that Nicole had moved to Montana from California just 18 months ago and was now attempting to impose suburban aesthetics on ranch country. He smiled, the same calm smile that had preceded tactical decisions in 2 combat deployments, and pulled out his phone to call his daughter, who happened to be a land use attorney specializing in agricultural protection laws. "Nicole," he said when she answered his call, You've just threatened to seize agricultural equipment on property that's been registered as working ranch land since 1947. That's a violation of Montana's Right to Farm Act, and it carries some interesting penalties. Would you like to discuss this before my daughter files a federal civil rights complaint, or shall we let the state attorney general explain agricultural protection laws to your HOA? The line went silent, but that's a story for another time.